Good afternoon. This is Sean Golding with Golding. Hope everyone had a good tax season. Let's talk a little bit about why the IRS is increasing enforcement for foreign and international information reporting, such as forms like the FBAR, Form 8938, 5471, etc. So first, let's start with who has to file the form, right? There's various different international information reporting forms we'll get to in a moment, and different types of individuals have to file the form. We're just dealing with individuals for purposes of the presentation. Citizens and residents are going to be the common categories, right? So like a U.S. citizen, a lawful permanent resident, whether they live in the United States or abroad, still required to file these international forms. It also includes non-permanent residents and non-U.S. citizens who meet the substantial presence test, which is a counting days test. It's a catch-all test, which means if you're here, you don't have to be on a visa, but typically you are, like an H-1B, an O-1, EB-5, etc. And you're here for a significant number of days in the current year and the 2 prior years, then you may meet the substantial presence test and have to file just as if you were a citizen or permanent resident. For the people who are only filing because they meet the substantial presence test, they may qualify for an exception, like the closer connection exception, or if they're on their first F1 visa for the first 5 years. There are some treaty rules that say if you live overseas and you're in a treaty country, you may be taxed as a non-resident, so you're only paying tax on your U.S. sourced income. But IRS takes the position that you still have to file all these horrible forms, noting that there was a recent case, Aroeste, which involved Mexico and FBAR, and the courts came down and did say taxpayers should not be subject to non-willful FBAR penalties because you shouldn't have had to file in the first place, because you qualified under a treaty election to be treated as a non-resident alien. So there is that case out there. Let's talk about some of the common forms to be filed. 3 of the more common forms are going to be the FBAR, which is FinCEN Form 114, not technically an IRS form, but still required to be filed each year. FATCA Form 8938, which is the Foreign Account Tax Compliance Act. That is part of your tax return or tax filing. And PFIC Form 8621. This can get infinitely complicated, but for purposes of this, if you have a mutual fund account, an ETF account, or a passive holding company, something like that, then you may have to file this form as well. This form, it can get tedious depending on how many funds a person has, what kind of income it's earning, and whether there's excess distributions if any elections have been made. Some other forms, Form 3520 is relatively common as well. It's for taxpayers who receive a gift or inheritance from a non-resident alien. Also for certain trust reporting, Form 3520A is specifically for U.S. owners of foreign trusts. And then Form 5471 and 8865, these are for foreign businesses and partnerships. Now, these forms are important. They border on some of them being relatively straightforward, like the FBAR, you just need the maximum account value. Then you get to like the 8938, which gets a little more complicated depending on if you have income generated from these assets. And then things like the 5471 and 3520A, 8865, those can be much more complicated balance sheets depending on what the ownership is. Things like income statements and balance sheets for people who don't have any background in that, it can be overwhelming, and it is entirely unfair. So why is the IRS increasing enforcement? Well, it's an easy way for them to make money, right? If you haven't first of all, the penalties can be astronomical. I mean, FBAR alone is $10,000 a year for non-willful. That adjusts for inflation, so it's closer to $15,000, possibly even more. If you're willful, it's 50% of the maximum value. That can be a lot of money. Someone has a lot of accounts. Even if they've only had the accounts for a few years, you could be looking at a 6 or 7 figure penalty. 3520 is a very easy way for the IRS to get penalties as well. Someone is here on a visa, or they're a permanent resident, they have no credit, they want to buy a home, they have wealthy family members overseas, they gift them $1 million to buy a home. They live in Southern California, so that's not a huge amount, let's say. And next thing you know, they don't know they have to file a 3520, and 5 months late is a $250,000 penalty, a 25% penalty on that gift, and there is no unreported income. It's insane. But The IRS has been increasing enforcement. Now, they were supposed to pull back the enforcement. That's what the commissioner had said in October or November of 2024 during an appearance at UCLA conference. Fortunately, the commissioner is no longer there, so it's sort of up in the air as to whether or not the IRS is going to go in that direction or not. In addition, what the IRS is doing with increased enforcement is for taxpayers who already received a penalty notice and may have a tax liability as well, they may receive a CP508C Notice, which means the IRS is planning on revoking or denying passport revocation. You won't be able to renew it. This can be a huge problem for taxpayers, especially if they live overseas. Maybe they're a U.S. expat living in a foreign country, but they're not a dual citizen. So the only passport they have is their U.S. passport. So this can be a big problem. For taxpayers who are out of compliance, there's various ways to get into compliance depending on the facts and circumstances. If you're willful, there's the voluntary disclosure program. It's not as good as the OVDP program was back in the day, but if you're willful, you don't have that many options. If you're non-willful, there's various programs available to you. There's the streamlined procedures, delinquency procedures, reasonable cause. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.